Good morning, everybody. This is Steve Holden, and I hope you're having a great morning. We're going to start the webinar here in just a minute or two. Make sure that we get everybody who registered on. So if you'll just hang for a minute or two, we will begin. Thanks. Okay, well, let's get started. Again, my name's Steve Holden. I apologize, I didn't put that up on the screen, so hopefully everybody's seeing the screen and the title of this webinar, The Hype and the Reality of the New Training Requirements. Many of you know, probably maybe all of you know now that there are some very significant changes to California law with what I'll call massive new requirements for training in the state, given the law that took effect on January 1. And as a result of that, a lot of people who do training or would like to do training see quite an opportunity to sell what they do. And the result that I've seen of that is a lot of hype and maybe not as much reality as there need to be. Obviously, we sell training and do training for our clients, so we could be subject to that same scrutiny and should be. But I think you'll see that the presentation today is for a different purpose, because I'm going to tell you something and give you an option that I guarantee you nobody else is going to give you as it relates to all the new training requirements. But the main reason we're doing this is we have been bombarded, might be a little bit of hyperbole, but we have definitely had a lot of clients who have been contacting us with questions and concerns about the new training requirements. And I think that largely comes from the hype that is out there from people trying to sell their training programs. And so I want to try and cut through that for you and give you solid information to work from in deciding how you are going to handle the new requirements for your organization. So let's jump into it. Let's see here. I need to be able to work my computer correctly. There we go. So what are we going to try to do today? What's the purpose? I've talked about it a little bit, but specifically, I want to give you an understanding of what the laws are, and to a certain degree, what they're not, an understanding of what options are available to you, and some risks and the potential liabilities that kind of follow from different ways you might approach dealing with the new law. Bottom line is to give you a foundation for charting the best path for your organization to deal with this new law. And it will be different for everybody, or can be very different for different organizations with different requirements. Okay. So what are the requirements? Let's talk about the law. What is required under the law? To do that, I'm going to give a little bit of a history lesson. This law, the training, the requirement to conduct harassment prevention training is not new. Before 2019, larger employers, 50 plus employees, had a requirement to do this training. So the training isn't new. We've been doing it for our clients with 50 or more employees for many years. What is the requirement? Conduct sexual harassment prevention training for supervisors. This is before the beginning of this year. It was only for supervisors, a 2-hour training, specific training requirements. Employees needed to be trained within 6 months of being hired or promoted into a supervisor's position, and every 2 years thereafter. Again, the training requirements, very specific what needed to be included in the training, and also very specific requirements for who could conduct the training. Okay, none of this is changing, but as we move into the here and now, after January 1 of this year, a significant change with those things that I've highlighted in black here on the screen. Now that same training requirement has dropped to all employers that have 5 or more employees. So many thousands of organizations who did not have to train by law last year do this year. The training for supervisors remains the same. There's a 2-hour requirement. The other key component of this massive new requirement is that all employers with 5 or more employees now also have to train non-supervisors. That training must be 1 hour in duration. Okay. Again, there's a requirement to train new people within 6 months of hire or promoting into supervisors. Then they have to get the supervisor training. And then you're going to be on an every 2-year schedule. One of the other big things out of the law is that because of what I still am convinced is a typographical error in the statute, where the year should have been 2018, but it is actually written as 2019 in the statute, all employers are required to train this year, even if they trained last year in 2018. Of course, that makes no sense, but nobody is copped to the fact that it's a typo. In fact, the Department of Fair Employment and Housing has kind of jumped on that and stated their position because of the way it's worded that everybody has to retrain this year no matter when you did your last training. So everybody is going to be training in 2019. Again, there'll be some options we'll talk about later, and maybe some of you won't. The requirements for trainers remain the same, and the specific training content remains the same, largely the same. All right, so that's this year, the here and now. There's some additional requirements that will take place next year on January 1. And that would be if you have any seasonal, temporary, or short-term employees, those that are hired for an expected duration of less than 6 months, you will be required to train them within 30 calendar days of their start or 100 hours of their work, whichever is shorter. So you're going to have to not have that 6-month window to get people trained. It's going to be compressed to the 30 days or 100 hours, If you are in ag and you have migrant and seasonal agricultural workers, as those are defined under federal law, then you're going to have to do the training that is consistent with the same kind of training that farm labor contractors are required to conduct under Section 1648 of the Labor Code. A few differences than the training for non-agricultural workers, but basically the biggest difference is you won't even have the 30-day calendar days or 100 hours worked. You will have to be doing the training at the time of hire, so it'll sort of be even more sped up. So that all kicks in at the beginning of next year. Okay, so what is the specific content requirement? What are these requirements of it? Well, first, this bullet point list isn't all of it. I ran out of room on the slide, but I put the most of it here, and you'll get an idea that there is a great deal of complexity in the regulations and the statute having to do with the content and training requirements. So the first requirement is that it be classroom live training or other effective interactive training. Other effective interactive training is not this wide open window. It's specifically actually defined in the regulations, and I'll talk about that in a minute when I talk about the options that are available. The content has to talk about preventing sexual harassment. The statute says this is sexual harassment prevention training. Not harassment in general, just sexual harassment. Now, we don't train on just sexual harassment. I think most don't, because when you dig into the regulations in any depth, you'll see that actually the content requirements go beyond sexual harassment. And in any event, it would make no sense to make this investment in training of your people to train them on only one aspect of unlawful harassment, since there are many other protected categories. So the other thing, though, you definitely have to have content that discusses harassment based upon gender identity, gender expression, and sexual orientation. And in fact, in a minute when we talk about the qualifications for trainers, the trainers actually have to have particularized experience and expertise in those subject matters of the law. You need to provide practical guidance on the laws themselves. Some definitional stuff is required so that people understand what the background laws are. You need to talk about remedies. You need to talk about the complaint procedures. You need to talk about investigations and how they are handled. You need to talk about confidentiality. And so all these components that the law has need to be shared with the employees, and they're all specified in the regulations in greater detail than this bullet point, mind you. The content must include discussion about the prevention of abusive conduct, and that's a defined term under the law. It needs to go over your individual policy on harassment prevention and familiarize the people with your policy, how it operates, what your expectations are, etc. Needs to provide specific practical examples for supervisors and non-supervisors to the education process. There needs to be questions and assessed learning through tests, quizzes, that type of thing, and skill-building exercises that you're really giving tools to people, not just hitting them with information from a PowerPoint. So the content stuff, there's a lot to it in terms of putting together content that meets all the details of the regulations, okay? Some other specifics out of the law that you should be aware of. It can be conducted individually, so you can plop somebody in front of a computer screen and do online training. We'll talk about that in a minute. Or it can be done in a group. There's the 2-hour requirement for supervisors, a 1-hour requirement for non-supervisors. The law says in the statute that those can be completed in shorter segments, but then when you move over to the regulations, you find that the classroom live training can be completed in shorter segments, but only as long as each segment is at least 1.5 hours long. And then the shorter segment requirement as it relates to online e-learning computer type training is more specific about how the program has to be structured in order to meet the legal requirements. Bottom line on that is, if you talk to people who are experienced trainers and educators on this subject, almost everybody would say it's ineffective to go to shorter segments. And keep in mind that the primary requirement is that you provide interactive, effective training. That's the first requirement, and I kind of blew it because I should have a slide that has that in big letters, and I don't. And so if the shorter segments don't get you there, you wouldn't want to use it. So for most people, we're definitely going to recommend against shorter segments. The other problem with shorter segments is the labor cost that would involve with it. It drags out the non-productive time of your employees. And I'll talk about that in a minute too. Can be completed with some other training. So the regulations specify, hey, if you're training on a whole bunch of other things, well, you can include this as long as all the content there, the time is there. But there is one problem with that. The regulations do specify for the sexual harassment prevention training that when you are training your employees, you have to do it in a setting that is different than where they do their regular daily duties. And so if you are doing this training along with, I don't know, like a regular weekly tailgate meeting in the field, and then you put it on right there, well, you haven't moved to a setting that is different from their regular daily duties, and you wouldn't meet the requirement there. So be cautious of that. Let's see. Oh, the other thing that's interesting is, so I said this applies to all employers that have 5 or more employees. Well, employer is defined as somebody who is regularly receiving services from 5 or more persons under contract. So let's say you have an organization, you say, I don't have any employees, I just use independent contractors. This may well apply to you even in that context. And obviously, if we get into independent contractors, that gets way more questionable in today's world post the Dynamex decision from last year. But so then the last thing that's a specific here is there are specific documents that the statutes and the regulations and statute require you to keep from the training. So you'll want to be aware of what those are and make sure you're in compliance with having those training documents. So the other thing that's right in the statute itself is that all of this content, all these requirements, the 2 hour, the 1 hour, you must do it within 30 days, and all that is a minimum threshold. The statute specifically said that there's nothing in all that detail that should discourage employers from doing more comprehensive training if necessary to meet their obligation to take all reasonable steps to prevent harassment and discrimination. So there could be a case where just ticking off the box of the minimums that are here isn't enough to actually make the case that you're doing everything you should do. So that's just something to be aware of. Okay, so what are your options? I mean, I think this is where most people are, and the questions that we're getting from clients and concerns and frustration. It's just, what am I going to do? What are my options? Well, let's go through the options. Okay, here are the options as I see them. Number 1, conduct live interactive sessions with a qualified professional trainer. That is, engage us to come out to your facility and engage your people, get all the content out, turn it into an experience that is something that's positive and that people really learn. The next is to do the same thing, but do it with your own personnel. If you have somebody in your organization who meets the qualifications as a trainer, there's no reason that you can do it yourself. So what are those qualifications for a trainer? You need to be an attorney or a law professor or a university professor who teaches employment law, or an attorney who practices employment law with specific qualifications for at least 2 years, or, and most of you are probably not going to have that kind of person, What you might have is somebody who is a human resource professional who has 2 or more years of specific experience in preparing sexual harassment prevention training materials, specific 2 years of specific experience and training in handling complaints of sexual harassment and investigating complaints of sexual harassment, or 2 years or more of experience advising employers or employees on sexual harassment prevention. So it's possible that you might have somebody who could meet those qualification standards. The other thing that the law provides for is if you have somebody and they're not quite qualified, they could build up their qualification by essentially team teaching with somebody who is a qualified professional. And the human resource department in the firm might kill me when I say this, but I'm going to say it anyways. That might be an option for us with some of our clients who want to build somebody up in their organization where we figure out a team teaching situation that can help you get there. Okay, the next is to do a live webinar training. Same requirements as 1 and 2, except instead of being in the same room, it's a webinar just like we're doing now. The problem with that, if you choose that option, you need to look at the regulations very carefully because there are very specific requirements about how you ensure that the participants are engaged and participating. They can't just sit on the other end and listen to a webinar the way you guys are today. There are very specific requirements on how the webinar needs to be run to get that participation and engagement. The next option 4 is an online e-learning program offered by a professional training company. There are tons of them out there. You can Google them and you will not have any difficulty finding people who provide sexual harassment prevention training through online modules. Most of them are going to have a fee for that. Usually it's a per head fee, and you put your employee in front of a computer and you pay the fee and they go through the training. And that company has hopefully looked at all the very specific regulations in California on how those programs have to be designed, who can design them, and how they have to operate. But be careful if you do that option that they have met all the California requirements, because keep in mind, that kind of training has been available for a long, long time, decades, and a lot of it is not designed based on the California law. It's designed based upon federal law and sold throughout the country. So make sure your program is specifically compliant with all the detailed regulations for California law on e-learning. But that's an option for you. And then the next would be an online program offered by the DFEH. So when the law was passed, it specifically says that the Department of Fair Employment and Housing, the DFEH, is required to create an online program for employers in California. So clearly the legislature, did a solid to a certain degree. They said, we're going to put this massive training requirement on people. We know there are paid for programs out there of many varieties, but we're going to offer something up from the government for employers to be able to come into compliance. Unfortunately, that isn't available yet. The requirement is to get it done by the end of 2019, but the program is not built yet. What does exist on the DFEH website is there is a bare bones PowerPoint with content, but you would still need a qualified trainer to use it in order to be in compliance with that. But in the future, there may be something from the DFEH. It's supposed to be coming later this year. And then here is the surprise. The thing I told you nobody's going to tell you is an option. Option number 6, don't do anything. Don't train. Or train, but if it's not fully conforming with all of these details that I told you, so what? Now, you might be going, really? Is he really telling us this? Now, first of all, you note that I put in parentheses, I'm not recommending it, but it is an option. Here's why it's an option. The law provides very specifically in the statute that your employees cannot sue you because you didn't train them. There is no cause of action or right to file a lawsuit by an employee who did not receive training in accordance with the law. By the same token, doing the training doesn't insulate you from liability. So you get sued for sexual harassment and you roll out the best training ever and all the documentation, and your trainer was this rock star trainer and they're a star witness in your lawsuit. It's a so what. It's not a so what, and I'll explain why. But it doesn't insulate you from liability, okay? The only way that you're going to get attacked for not training or not doing training that is conforming is the DFEH can go to court and get an order requiring you to do the training. That is highly unlikely to happen in 2019 and highly unlikely to happen in most instances beyond 2019. So it's not a high risk that the DFEH is going to get an order. And if they did, and the order is to have you do the training, so to a certain degree you go, so what? Where you would get dinged if you chose this option is if you have a lawsuit and you're defending some sort of a claim or lawsuit. Maybe it's not even a lawsuit. Maybe it's pre-lawsuit. But where you're going to get dinged is if the plaintiff's attorney knows that you didn't train or you didn't do really good training, it will be used against you to make you look like you did not care. Very easy to do that, very easy to pick it apart. And if you do that, and you're successful in, the plaintiff's attorney is successful in convincing a judge or jury that the employer really didn't care that much about sexual harassment prevention, really didn't put any effort towards trying to prevent it, where you're going to get dinged is the jury is going to punish you. So it's going to cost a lot of money because the jury is going to give a lot more money away, whether that's in just general damages or punitive damages. That's where not training is really going to hurt you. It's not that somebody can sue you for not training. It's what they make you look like for not training in a sexual harassment lawsuit. So that's why option 6 is something for some people to consider, that if for some reason you just could not train in 2019, is this guy going to fall? Maybe not. Again, I'm not recommending it, and I'll explain why. So here are the options. Before I get to that, though, here are the options that we offer from the law firm. We only do live interactive training. We don't do computer stuff because we don't think it's effective, and it certainly isn't within our expertise. I'll explain why I don't think it's effective in a minute. So we have 2-hour supervisor training where we come out to your site and we train your people that are supervisors. We have 1-hour non-supervisor training. We've had those and we've been doing those for years. What we created this year, because of the new training requirements, is this really cool combined program where both the supervisors and non-supervisors are trained together in a single 2-hour session. And the way we do that is everybody comes in for hour 1. All the content is based upon the non-supervisor general information about sexual harassment prevention training, blah, 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 blah. Then the non-supervisors can be released to go back to work, and we spend the second hour with supervisor-specific material. The trainers have been getting phenomenal feedback on the new program and what it really does in terms of culture building to have supervisors and non-supervisors together and interacting with the exercises that we provide on the training. So that's what most people are going for now because of the efficiencies of it. But again, depending upon the number of employees you have to train, all different manners of combinations might apply. Then the last option that we provide is multi-employer programs at a conference facility that would be scattered around Northern California. Because our clients are all over Northern California, we will be picking up conference facilities at various locations in Northern California, setting a date, sending trainers there where you can send in employees And if you're a small enough employer, all of your people to be trained, the difference is you'll be training alongside other companies. So it won't be just you. It will be you and employees from other companies. And we are working out how to make that work really effectively for those of you who have a smaller number of people to train, and it makes sense to do that. Now keep in mind, in that instance, there's an increased cost, obviously, for you to get your people to wherever that neutral, central facility is. So those are the options that we are offering. So now, what are the potential liabilities? Well, I actually talked about this already. I jumped ahead of myself. So what are the potential liabilities? Well, we talked about it. The whole issue of if you don't do training at all, can you be sued for that fact? No. Can the government come and force you to do the training? Yes, but it's highly unlikely that that'll ever happen. The potential liability is you don't do the training, or you do crappy training, or you do it with somebody who really isn't qualified and they get picked apart as a witness in the lawsuit for sexual harassment, and it really hits you with the jury award or what the judge ultimately does in terms of not giving you a defense. That's the potential liability. And so now I've hit you with all this stuff, and you might be sitting there going, geez, I thought you were going to try and help me out in this webinar today, and what you did was you just gave me this massive information, and my head is still exploding on how am I going to meet this requirement. What should I do? Well, my recommendation is you train. The option of not training is an option, and for some, it may be an option that you go with, but I don't think it's really what you want to do. Ultimately, whether it's this year or next year, you definitely want to train. There are really good reasons to invest in the training and doing it well. You think about, I mentioned that I'm not a fan, and the people that I've talked to who really know how to do this stuff are not fans of plopping somebody in front of a computer screen and using an e-learning tool. Why? Because it's, for the most part, not engaging, not exciting, and it doesn't have the same effect of changing how somebody actually behaves or creating the positive culture that you have the opportunity to do when you have live interaction of your people together. Because at those sessions, you can do things more than just the training of the material. You can bring people together and having them work together and create engagement between employees that goes well beyond preventing harassment. It leads to better performance between the employees. You just can't do that if you're plopping somebody in front of a computer screen. The other reason I'm not a fan of doing the computer screen method is that there's a cost to it. Well, I should say, if you can get it for free, it may be a good option in some instances for some of your people. If there's a cost to it, what we've seen in terms of cost, it starts to be close to, or in some cases even more than the live trainings when you start counting heads. But the other thing is the biggest cost to this training requirement under California law is that you have to pull your people away from doing their work for 1 or 2 hours to go through the content. It's that lost time of work, the lost opportunity cost, that is the biggest cost in the training requirement, not the cost of the trainer or not the cost of the e-learning fee per employee. So you want to definitely take that into consideration and maximize what you're going to get out of that lost opportunity cost. That's why I think live training is the way to go. It's way more engaging. But for many, you may not be able to do live training. You know, where are your employees? Where are your facilities? Are they spread out all over the place? I have somebody who's working from home and they're in the middle of nowhere. Well, you may find, and what we're doing with clients and what I'll encourage you in a minute is, if you're struggling with how am I going to make this work for my employee population, don't hesitate to call us, because I know Melissa and the HR consultants have been working through plans for for clients to do it. And a lot of times it's a mix of the different types of training that is the most cost effective and way to get the training requirement done. So it might be some live training sessions, it might be some e-learning stuff, it might be the webinar option. Again, it may be a combination for you because one size does not fit all. All right, that's it. That is all I've got, other than to try and answer any questions that you might have. That's the whole point of today, is trying to get your questions answered. And so I'm going to jump into, I did this yesterday too. I am so lame. Sorry. I forgot that somewhere on your screen there's a place to type in questions. You guys are smarter than I am, so you've already done that, or a number of you have. So if you haven't, just know there's a place to type in a question. If I don't get to all of them now, just know that we will get back to you with answers to those questions, or you can always call us and we will try to answer any questions you have about how you're going to get all this taken care of in 2019. Okay, first question. Just for clarification, effective 2019, we must be training all non-management and management. Answer, yes. Also, the 6-month rule applies now in 2019 as well. Yes. So, yes, you have to train managers and supervisors, 2 hours. Yes, you need to train non-managers, 1 hour of training. You have to train them all within 6 months of hire, and your supervisors, if they were a non-supervisor and then they're promoted into a supervisory role, they need to go through the supervisor training within 6 months of being promoted. All right, great question. All right, the next one. Does e-learning have to be completed away from the normal work area? That is a really good question. I would have to go back to the regs to find, well, hang on, maybe I can do that right here really quickly. It is not in the e-learning details. That I do know. So I'm going to say yes, because that section talking about it being away from their setting of their daily duties is not in the e-learning section. So I think the answer to that is yes, but that sounds like a crazy requirement if you think, oh, well, I employees people, they sit at a desk and they have a computer. Now I have to take them and put them in a computer somewhere else. But I think you've just pointed out one of the ambiguities that is you frequently find when you start looking at the laws in detail. So if you want to be technically correct, yeah, I guess I'd move them to a computer somewhere else. Are you going to have any kind of major risk if you have them do it at their computer at their own desk? I think the answer to that is no. Okay, the next question. I heard that the Senate passed SB 778 last week with an urgency clause which extends the training deadlines in SB 1343. Any thought on whether this will pass? I honestly do not have an answer for you on that. So no, I can't give you a prediction on that. I don't think it, I think that's great. If there's an extension, it'll reduce some anxiety of people. That's fantastic. But I think if what you're doing is now doing some long-range planning of knowing, hey, we are going in the future going to have to train our supervisors for 2 hours, our non-supervisors, and we're going to have to do it every 2 years. And when new people come on in the non-ag environment or non-short-term employee, we're going to have to do that within 6 months of their hire. You start planning for that based upon your employee population and where your facilities are and what types of employees you have, how you're going to meet that requirement into the future with quality training in an economic fashion. It's going to vary for you from somebody else. As you start to look at that, if you're doing that now and you're planning for that now, you're going to be fine. whether this passes or doesn't pass. Okay, next question. How can we get information on your fees for coming to the site to our company to do training? That would be contact us, and you will communicate with Melissa Johnson in our office. Melissa is the expert on that. She's coordinating all the trainings, and so just contact Melissa Johnson or anybody here, and we'll get you to Melissa so that that gets taken care of. And she may have some of the others in the office support her with that, given the amount of people who are needing training this year for sure. What next? What is the best way to determine what the cost would be to do a combined on-site training for our company? The best way to determine that is give us a call. And what we do is we figure out what kind of training is going to be best for you and fit your needs, how many people are going to be involved so that we determine how many trainers we need. I should know this, but I'm lame and I don't. But we did set an outside limit for a single trainer to train. So if you had 500 people, we are not going to do that training with a single trainer, because there's no way that we can accomplish the kind of engagement and fun and effectiveness of the training where we have one person and an audience of 500. In that kind of situation, we've had people say, no, but I still want all 500 done at one time, then we work out a situation where we bring multiple trainers so that there can be greater engagement directly with the trainer in that situation. So it'll just depend, but give us a call and we can work it out with you. Do we just call or email Melissa to request? Yes. So poor Melissa after this is going, if she does not get back to you immediately, I did not intend this, but she's going to be probably bombarded based upon these questions. Next question, what do we do if an employee cannot read or write, also not speak English? Would multiple training sessions be required? What if your employee, well, let me deal with that one. And we in California have dealt with that a lot with Spanish language. So the very best option, if you have employees who are Spanish speaking or other languages, would be to find somebody who has the experience and the expertise and the engagement and the entertainment ability of our trainers who speak Spanish fluently. We don't have that available. That's the best option if you have Spanish folks. We have tried to find that person. We're still trying to find that person. We thought we found them earlier this year, but we didn't. The next best option, if you can't find that person, is to do it through a translator. And we have certified translators who can come with our trainers to deal with Spanish speaking. If you have a smaller number of Spanish speaking, again, that gets into sort of, well, maybe we do multiple sessions. So it's just going to depend. Okay. What if your employee refuses to attend a webinar or a class? Well, I would discipline them. You as an employer are entitled to require certain things of your employees, and this would certainly be one of them. So I would discipline them. I'd ask them why. I'd use it as an educational opportunity to try and build a better relationship with that employee. And I'd say, well, why are you refusing? I try to understand it, but ultimately I would explain to them, hey, this is a requirement under the law. We have to put you through this training, even if we didn't want to. So that's how I'd handle that. Let's see. Last question looks like here is, do the employees receive a certificate upon completion of the class? Yes. In whatever form you use, you are going to want to have documentation of how it goes. If you are utilizing us, we provide you with the documentation that you need for both your records and certificates for employees. And so, yes, the answer is yes to that. Well, that's the end of the questions that I have here. And so with that, I'm going to thank you for joining us. Again, the whole point here is to try and get you the information you need to deal with all this. If you need further information, don't hesitate to give us a call. Have a great rest of your Wednesday and a great rest of the week.